Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As in the series of Jurisprudence 2, I have discussed first important question relating to the legal personality. In this video, I am going to discuss with the second important question, that is relating to the legal rights and legal duties. If we talk about the rights to which we are entitled and which are inherent in every human being since birth to till death. If we talk about the rights, it is the duty of law to protect the rights of every citizen. Due to being a citizen of the country, and the people are given certain legal rights, and it is the duty of every individual to protect the rights of each individual. If we talk about the rights, these may be legal rights or maybe moral or natural rights. If we talk about the legal right, it is an interest which is recognized and protected by the rule of legal justice. While on the other hand, moral rights are the interest which are recognized and protected by the rule of natural justice. Right, the violation of which may be moral wrong. This means, in general terms, we can say that an action which is permitted by the law, that is called legal right, or the act which is recognized or protected by the state, that is called legal right. And the definition of the legal right has been given by various jurists such as Orlean, Austin, Pollock. Many jurists have defined the term legal right. If we talk about the term legal right, a legal right is an interest which is protected and recognized by the rule of law. And it is an interest which has its duty and disregard of which will be a wrong, will be punished by the state. This means main difference between the legal right and the moral right, that is with respect to sanction. If we talk about the legal rights, these are confined and protected by the state, and in case of violation of the legal rights, state itself imposes penalty on the wrongdoer, while the moral rights are not confined and protected by the state, and the moral rights are protected by the thin layer of social fear. If we talk about the definition of the legal right, first definition is given by Professor Hearing. According to Professor Hearing, right is a legally protected right. No one has any other right than always to do his duty. And the Duguid about the Professor Duguid and Kelson both negativity the idea of right. If we talk about the definition of legal right, Professor Austin has also defined the term legal right. To Professor Austin, right is a faculty which resides in a determinate party or the parties by virtue of given the law, and which avails against a party or parties. According to Professor Salmon, legal right is an interest recognized and protected by the rule of right, and it is an interest in respect of which there is duty and disregard of which that will be a wrong in the eyes of law. We talk about the Professor Salmon has defined the legal right from the different angle. While the Professor Holland defines the legal right as the capacity residing in one man of controlling with the assent and assistance of the state the actions of others. It is clear that Professor Holland follows the work given by Austin. If we talk about the different characteristics of the legal right possesses the certain characteristics. First characteristic, that is the subject. This means in every legal right there is some person who possesses the legal right, and that person is called subject to the legal right. And the second characteristic, that is the object. A legal right operates against some person upon whom lies the correlative duty, and that is known as object. The third is matter of content. We have content or nature of the substance of the legal right. That is the action or the forbearance by which the person is obliged and is bound. And the next element of the legal right, that is the acts. The acts or the omission relating to something which may be termed as object or the subject matter of the right. And the object of the right is the thing over which right is exercised, or the actionable claim in respect of which there is right. The next characteristic of the legal right, that is the title. Every legal right has a title, that is to say certain facts or the events by reason of which right has become vested in the owner. So these are the certain elements of the legal right. If we talk about the duty is an obligatory act. That is the act opposite of which will be wrong. However, all the acts which a man ought to do and do not constitute the constitutive duty. For example, a servant has duty to serve his master. The child has duty to obey his parents. Means a duty consists of certain positive act. If we talk about the duties, that can be moral duty or it may be legal duty. Duty may be moral as well as legal duty and maybe one of them also. For example, there is a legal duty not to steal anything belonging to others. For example, sale of adulterous milk, whether knowledgeable or not, no to steal. These are the certain duties which comes under the category of moral duty as well as the legal duty. If we talk about the classification of rights, that can be classified under the certain heads. First classification, that is the perfect and imperfect rights. About the perfect right, that implies the right which has a correlative duty. It must be enforceable in the court of law. Hence, remedy must be available to the aggrieved party, that is whose right is violated. Then such right, that is known as perfect right, against which there is remedy. If we talk about the imperfect right, these are the rights which are recognized by law but they are not enforceable in the court of law because of the some defect in the right. For example, imperfect rights are the right against the foreign state or the foreign sovereigns. Second is time-bearer debt. So these are the rights which are recognized by law but they are not enforceable in the court of law due to certain defects. Right, that is generally recognized by the maxim ubi jus ibi remedium. This means where there is right, there must be remedy. But if we talk about the imperfect right, that does not comply with this maxim. This means this maxim does not apply to the imperfect right, while this maxim applies to the perfect rights. Second type of classification of right, that may be positive right as well as negative right. A positive right is corresponding to a positive duty. A person having positive right can compel the person to do the positive act on whom such positive duty has been imposed by law. Positive right look forward for a active assistance of the other party. If we talk about the negative right, that is correspond to the negative duty. A negative right puts obligation on the person on whom the negative duty has been imposed to not to do certain act. A positive right demand passive acquiescence only. For example, A brought watch from B. That is the positive duty on B to hand over the watch to A, and if the price of watch has been already paid. Second example is if A is the owner of his house in the location and there is certain positive duty on the other persons not to disturb the peaceful enjoyment of that person. And third type of right, that may be right in rem and right in personam. If we talk about the right in rem, that is right available against the whole world, not against a particular person. While on the other hand, in the case of right in personam, that is available to a specific person. That is against the specific person or the persons. For example, X has a right to enjoy the premises he have. Right, he has right not to be disturbed by the others. If anyone violates this right, then that is right in rem because there is violation of legal right of that person. A was having the legal right not to be disturbed by the others. Second example, that is A sings for B's club. Then A can sue only B to get the payment only. So that is the right that comes under the category of right in personam. In case there is contract between two persons, A and B, in case of violation of right by B, then there is a affected party, that is only A. So this means in case of violation of right to contract, there is violation of right in personam. There is a violation of right of a particular person, not the right in rem. So right in rem means a right which where there is violation of right against the society, not against a particular person. All the crimes comes under the category of right in rem, where there is violation of legal rights of the person. Also the torts comes under the category of right in rem, where because in cases of tort there is violation of legal rights of the person concerned, and where is violation of legal right, that then it will be right in rem, not the right in personam, because it affects the whole of the society, not a particular person. This means if A makes a painting for B and B promises to pay A for this painting, so A can sue only B if he denies the payment. Then this right is known as right in personam, that is available against a particular person only. The right may be right in re proportia and right in re aliena. If we talk about the right in re proportia, that is a right in persons of own property. Talk about the right in re aliena, that is a right in the property of somebody else. It is also known as recumbencies. That may be four kinds of recumbencies. That may be easement, securities, lease, and trust. Second type of classification of the right may be the primary right as well as secondary rights, or means principal or accessory rights, or the antecedent and remedial rights. When a right has its own independent existence, that is called principal right. While on the other hand, where a right is associated with the principal right, so associated right is called accessory right and it does not enjoy the independent existence. For example, A has principal right that no one should interfere in the peaceful enjoyment of that person in his premises. In case anybody does so, A can invoke his right to receive the damages, which is accessory or remedial right. Next type of classification of the right, that may be property right or the personal right. Right may be property right as well as personal right also. Means where a person's right in relation to his own property, whether it may be corporeal property or incorporeal property. If we talk about the personal right, that is relating to person, where the right is arising out of the status. A's right to reputation, that is called personal right. Means every person has right to reputation, and if anybody defames any person, then there is violation of personal right of that person. For example, A's ownership of the house is his property right, while the personal right is non-valuable, non-transferable, while the property right can be transferred, that is valuable and transferable also. Next type of classification of the right, that may be vested right or the contingent right. An estate is said to be vested right when it gives present right to take the immediate possession of the property. Immediate interest in the gist of vested interest, being complete in itself, is transferable and inheritable, while on the other hand, a state which gives a present right to take the future possession of the property, that is said to be the vested right. Contingent right means which depends upon the happening of a particular event. So the contingent right becomes a vested right on the happening of that event. So this was all about the classification of the rights. If we talk about the classification of duties, that duties can also be classified under the certain heads. First classification of the duty, that may be positive duty or the negative duty. For the positive duty, that puts an obligation to do an act on the part of the person on whom it is imposed, while the negative duty implies the forbearance or the refrain on the part of person to whom it is imposed. For example, A brought a car from B. Then B is under obligation to hand over the car to A. Here the B is subject to the positive duty. While if A possesses a house, then others are under a legal duty not to interfere in peaceful enjoyment of the house of that person. Here others are subject to the negative duty. Second type of classification of the duty, that may be primary duty or the secondary duty. If A possesses a house, then others are under a legal duty not to interfere with the peaceful enjoyment of the house of that person. Here others are subject to the negative duty. Second type of classification of the duty, that may be primary duty or the secondary duty. If we talk about the primary duty, that has an independent existence, while the secondary duty depends upon some other duty. Generally, the primary duty is violation brings the secondary duty. Where the violation of primary duty takes place, then the secondary duty arises. For example, not to defame a person, anybody, that is the primary duty. In case of violation of the primary duty, he will be under obligation to pay the damages to the person defamed. That is the secondary duty. Next type of classification of the duty, that may be relative duty or the absolute duty. If we talk about the relative duty, that implies corresponding right on a person or determined body or the person or the determinate body of the persons, while the absolute duty implies no corresponding right in a person. That is also one of the most important questions relating to the rights and duties that can be asked for 20 marks or the 10 marks. And if you have any doubt, then you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.